Good afternoon and welcome to Legal Access. We get together each and every Thursday at this time to give you access to different aspects of the law. That's what I'm saying. Today we're talking about premises liability, which is just another fancy way of saying if you get hurt on somebody else's property, do you have a case? Do you have a lawsuit? With me on the panel here today to answer those questions for you is Ian McGuire from the McGuire Law Firm.
Good to see you, Dave.
And also Rick O'Neill to your left.
Good afternoon, everybody.
Good afternoon.
Just the two of us today. I think Tiffany's going to join us. She got stuck doing a doing a deposition.
Yeah.
So it's just two of us. Rick, of course, practices in Myrtle Beach, and he's on with us a lot, and he handles a lot of premises liabilities cases our firm does, and they're a little different maybe than auto cases in that
Right.
The vast majority of them end up in litigation. So you sort of have to screen them a little differently. But if you have any questions, if you own a business and have premises that you own, or you have any questions regarding premises, give us a call at 843-848-8080. But that's right, Rick, isn't it? Where just because you get a call and somebody's hurt on the premises doesn't necessarily mean they have a claim, right?
Right. You know, the courts have said that just because you get hurt, let's say at a retail establishment or a restaurant or something, that those types of businesses are not just an absolute insurer of your injuries. You still have to prove a fault or negligence, and there's, it seems like inevitably in a premises case, they always say, well, the claimant is just as much at fault or more at fault than anything the business contributed.
Right. But even though they might not be responsible for a lawsuit, a premises, they still do have insurance to be able to help you with medical bills from time to time.
Yeah, so even if you didn't think you can prove liability, prove that the premises owner was negligent in any way, it's still important to have a claim filed because you very well may have medical bills or wage loss, and you very well may be able to recover because there'll be most businesses have a no-fault policy.
Right.
It might be $1,000, it might be $10,000, it might be more than that, it might be $100,000, but there's a policy where it'll pay for your medical care that's not paid for by other insurance. So it's definitely worthwhile, even if you feel like, oh, this was my fault, it wasn't anyone else's fault, to at least let the business supervisor or whoever's working that day know that the incident occurred.
So if you've been hurt on somebody else's property, or if you own property, or if you're a manager of a business and you want to know what your responsibilities are, give us a call. The phone number's on your screen, 843-848-8080. And again, if you'd like to talk to a lawyer, usually consultations are free for premises liability cases. So I would just suggest that you call either Ian or Rick or somebody else to find out what your responsibilities are or what your next move might be. We've had a couple of high-profile accidents that have happened. Unfortunately, they've ended very poorly, where some young people had accidents in pools. They've either been pools or lazy rivers around some of our resorts in the Myrtle Beach area. If you put up a sign at your pool that says, hey, no lifeguards on duty, you swim at your own risk, does that exonerate you from any kind of liability if somebody gets injured or worse?
Well, I mean, it's a good factor as for the defense. But I mean, if you're on notice that there's dangerous conditions and that you should have had a lifeguard or lifeguards, then it's not going to be an automatic win for the defense.
By any means. I mean, you're making money off a product or a service, then at some level you have a duty to make sure that the premises is safe. So if from a reasonable standpoint it's foreseeable that an injury could occur on the premises and you take no steps, and in your example, right, some steps were taken because they put a sign up. That's a start. There's never, or rarely is there ever going to be an absolute. I know you ask us questions and we always joke that, oh, it's a lawyer response, but it really depends on all facts in a case.
Right.
And when someone dies or has a serious injury, obviously those facts are going to be looked into with a lot more scrutiny maybe than they would be if it was very minor injury. So that's just the way it's going to be.
Those are at public pools or with business pools. What about a private pool? What if somebody has a pool in their backyard and somebody gets injured in there?
Well, there's a lesser degree of duty to prevent injuries. I mean, there should definitely be a lockable fence around a pool to prevent younger kids from getting in. But I mean, still, what a reasonable homeowner would do to keep his pool area safe.
Yeah, we've talked about the attractive nuisance
Right.
doctrine, where a child might be inclined or attracted to go on a premises and play, and so that might be something foreseeable. And if it's foreseeable, then you have a duty, like Rick said, to take steps such
Yeah.
as putting a fence around the pool to make it safer for children, because at all costs, as a community, we
Sure.
want to protect our children, right?
As far as attractive nuisances go, I mean, if you put up a bouncy house for your kid or a swing set in the backyard and some kids from a block and a half over come over and start playing in your backyard and they get hurt, are you responsible?
Potentially. You know, it's, you know, again, you probably have some duty. If everybody's finished playing on the bouncy, deflate it. If you can't deflate it, have it removed from the premises. But that there is potential for a claim. But I suppose in life there's potential of anything happening, and we don't do nothing all the time because of the potential. But we want to take reasonable steps, and it always comes back to that: what's deemed reasonable. And sometimes a jury of 12 in
Right.
South Carolina are the ones who decide that.
Speaking of reasonable, what's reasonable for a business owner as far as the safety that they have to give to the people who are shopping at their location, as far as people who might come out and want to do somebody harm in that business, or if a business gets robbed, or if somebody is in their parking lot and something bad happens to them there?
Yeah, and I'll let Rick talk about this as well. Our firm has handled a lot of those over the years, and they're very case specific again, but there certainly is a duty that you know, in these kind of cases, we hire experts. The experts will go through police reports. They'll go through all kinds of different reports to demonstrate that it's a safe area versus an
Right.
unsafe area, and that there's a lot of different criteria that will come into play in those cases. But if you're making money based on the business on a premises, and you have reason to believe that it's not going to be safe,
Right.
or you should have reason to believe that it's not going to be safe for people that are occupying the premises that you're making money off, then you have to take steps, or should take steps, to make sure that you know, the people that are coming on your premises are safe.
Right. I mean, sometimes there's just a deterrent effect. Even if a certain business has never had any violent crime there, if there's no surveillance system in place, I mean, these things are relatively cheap nowadays. Just the fact that there is signage up and criminals can see, hey, these premises are covered by surveillance cameras, and that creates a deterrent effect. So, I mean, you have a duty as a business owner to protect your employees, also protect your customers.
Right.
And do what's reasonable. And cost is one of the factors, but it's case by case. But this is a modern age. You're held to a standard to sort of foresee that these things are going on in society.
You might want to have security on your premises, and those are all, again, case by case,
Right.
and business by business, what needs to be done or should be done.
Our topic here today is premises liability. The phone number is on your screen if you'd like to give us a call, 843-848-8080. Let's go to Surfside Beach. We have Gretchen on with us right now. Hi, Gretchen. Thanks for calling in and thanks for holding. What's your question today? Gretchen, you there? Go ahead. Don't know if she's going to be there with us or not.
Doesn't sound like it. Sound like a foghorn or something.
Yes. Tell you what, we're going to run to a break here real quick. Maybe we'll get Gretchen back in case she wants to get back on with us. If you have any questions about premises liability, give us a call. Phone number is 843-848-8080 right here on Legal Access. Welcome back to Legal Access. We're talking about premises liability here today. If you've been injured on somebody else's premises, or if you're the owner of some premises and you have to worry about whether or not somebody gets injured on your watch, make sure you give us a call here today. We'll answer all your questions, 843-848-8080. And I know that the difference between having a case against a business is different than having a case against a municipality or any kind of a city. But I mean, if you trip on a sidewalk and injure yourself, or if you're on the beach in the Myrtle Beach area and something happens to you, what's the difference between bringing a suit against a municipality versus bringing a suit against a business?
Well, number one, there's a shortened statute of limitations, a deadline to bring a lawsuit. Number two, generally there's not punitive damages on the state level against a county or the state. And there's also caps on the amount of damages. They're pretty much very low caps of what you can recover. Even in a death case, it would surprise you to know how low they are. So that's one thing. And then there may also be some different procedures on how to set up the claim, notify the government agency on that the claim's being made, and so on.
And you may have to sometimes show gross instead of just normal negligence, right, on some of those claims, just a higher standard. Yeah, and you know, the statute of limitations is generally 3 years in South Carolina. It could be limited to, it could be a 2-year statute.
Right.
In municipality, there's a way to increase that back to 3 years, but generally in municipality, more so than ever, you want to sit down with an attorney right away if you think there's a potential for a case against a municipality. You know, there was a time you could not ever sue under any circumstances. So they came out with this Tort Claims Act, which, as Rick has really gone through and outlined it really well, is that there's limitations on what you can do against municipalities, and they're harder cases. People come into our office and there's a case against a municipality. They're more difficult, frankly, to prove and to get recovery for our clients. But there's also cases where it's so blatantly awful. Right. The fact of in a municipality case that there can be large cases.
I think we have Gretchen back on the phone with us in Surfside Beach. Hi, Gretchen. Thanks for calling back. What's your question today? Maybe.
I mean, I hear her voice. I just can't.
There's something with her signal that keeps overriding. What's going on there?
And Gretchen, maybe what you can do is you can call in and ask your question sort of off the air, and on the break we can find out what it is and we can answer it for you.
Let's go ahead and start from the beginning. If you are a business owner or the manager of a business and somebody gets injured on your premises, on your property, what's the first thing that you should do as a business owner to protect your rights, but also to protect the person who was injured?
Preserve the evidence, whether you're the person injured or you're the business owner. You need to preserve by photographing, downloading video footage of what happened, collect witnesses' contact information, take witness statements, notify insurance companies on both sides. The business owner needs to notify their insurance, hey, there's been a claim made or there's been an injury made, because if you don't let your insurance handle the claim, they may later say, hey, you did not let us handle this, adjust this claim, and we're not going to cover it. And then it's, the business may be on the hook for the claim.
So if you slip and fall in somebody's business and you jump up and start taking pictures, a jury is not going to look at that and say, oh, look at this guy's just trying to make a quick buck.
It's if you in that way, it sounds like a bad fact, but
yeah. And in the old days, it would be more scrutinized, I think, and questioned if someone did that. In this day and age, when everybody has a cell phone, I think there's an expectation that there's going to be video. I think Rick's absolutely right as far as the company goes. There's a duty to preserve any evidence, even if it's hurtful to the business. The worst thing you can do is get rid of it, and then you might get to court and there may be a charge that they should consider that there was evidence because it wasn't preserved properly, and that doesn't make anybody look good. In fact, it brings more questions
It just seems like there's a reoccurring problem when I bring a premises liability case with video footage. If it helps the business or the premises, they've always preserved it.
Yeah.
If it hurts them, we don't have cameras that cover that area, or we didn't preserve it. So, I mean, really, if you get a lawyer involved, we're right on it, having the video footage. We send someone to the business and also the corporate offices and tell them, listen, a claim's being made, and outline their legal duty and cite the applicable law and tell them, put them on notice so they can't have any wiggle room later on by not producing evidence that should be fair to the fact finder.
You've been hurt on somebody else's property, and they come to you and say, hey, do we need to call you an ambulance? And you go, no, I think I'm all right. And then 2 days later, you find out that you wrenched your back and you can't move. How is that going to affect you moving forward?
Well, I mean, they're definitely going to use that against you.
But the flip side is, I have been frustrated sometimes where these defense attorneys will light into the individual and say, you weren't hurt bad enough to get an ambulance, the client will say, well, I wasn't dying, and there's people that might be, and I'm not going to take the ambulance in a situation like that. So, I don't know. I don't think people should feel like I'm in an accident, I got to get an ambulance, or it's going to come back to bite me, because I don't know if it really does. I think people look at each set of facts and what's reasonable, and if you're not a litigious person, you want to go home and lie down and think in 2 days everything will be fine, and when the opposite occurs, it's worse in 2 days, well then you do what's reasonable, and that's go get medical care then. So 6 months go by and you haven't been to a doctor, and you go, that's a different story probably.
We're talking about premises liability here today. On the phone we have Schuler with us. Hey Schuler, thanks for calling in. What's your question for the panel today?
Okay, my son at the time was 13, and he got hurt on school premises, and he broke his wrist. They was, skating, and they didn't have no protected equipment at the time, and he tripped from the person behind him, fell on him, and he fell on somebody else, but he broke his wrist. And it happened on school premises. And the first thing we did was we wasn't able to take pictures at the time, because when he got home, we realized that he had a broken wrist. We thought it was fractured, but when we took him to the emergency room, it comes out that his arm was broken. His wrist was broken, right? We got a lawyer involved, but they got in touch with all the people that was involved in it. And we're still having problems receiving, finances behind that. The school did not inform me that my child got hurt. They didn't let me know nothing. All they did was give him a warm compress, put it on his arm, and just send him home. They didn't, do anything professionally pertaining to my child.
Yeah, well,
and
it sounds like you did the right thing. You went and obtained counsel, and that's what we definitely advise you to do. There are always tricky cases when children are hurt at school, but there certainly have been numerous cases where there was, the school was, or the school district was found to be liable. So, sometimes the wheels of justice, especially in these kind of cases, turn slowly. So I would just stay in touch with your attorney, and don't give up on it. Sometimes it just takes a while.
Right. This is another claim against the school district. Is a governmental entity, so it's under the South Carolina Tort Claims Act, which is a harder row to make those claims. So remember the 2-year statute of limitations. Also, just in my experience for doing this 30 years, is these things tend to end up never settling. You just pretty much have to file suit to ever get a resolution of a claim against a governmental agency. It's just the reality of it.
Right.
And we're sorry it happened
Yes.
to your child, and hopefully you will get treated fairly, you be
Right.
treated fairly and get compensated properly. But just hang in
Right.
there with your attorney, because it's just, these things take a while.
Yeah, stick with it, Schuler, and thanks for calling in here today. When we get back, we got to go to a break here right now, but when we get back, we'll have less than 10 minutes. So if you have any last-minute questions about premises liability, now is the time to give us a call. The phone number is on your screen, 843-848-8080, premises liability. That's our topic here today on Legal Access. Welcome back to Legal Access. We're talking about premises liability here today. Still got a few minutes left. If you've been hurt on somebody else's property, or if you own property and you want to know how to protect yourself in case somebody does get hurt on your property. The old philosopher, a couple hundred years ago, said, if a tree falls in a forest and nobody's there, does it make a sound? Well, Gretchen called back and she had a tree question. So her question is, a neighbor's tree fell on her property. It probably made a sound, but it also caused some damage. Who's responsible for the damage from that tree?
Shockingly, I'm going to start by saying it depends, and it does. But if there's potential for the people if the tree was on their property and it fell into another property, there's potential for them being liable if they were on notice or had reason to be on notice of a dangerous condition, and they didn't do anything. If the tree was
Yeah, it was showing if the tree had a history of limbs dying and breaking off. You could just look at it and tell, hey, this tree is not healthy.
Yeah.
And
For instance, if you sent an email to your neighbor, or you sent a letter and said, hey, we're worried about this, and they didn't act on it, I mean, there's potential that there could be a claim against the
Right.
neighbor. More likely, it's something where you would get in touch with your homeowner's insurance and go about it that way, probably, right? Because if it's an act of God and there's nothing that could have been done, but potentially, if it was a dangerous condition that should have been dealt with before, it was foreseeable that somebody could get hurt or property could be damaged and it was ignored, then there very well may be a claim. You might get in touch with your insurance company and they might want to do a little research into it, because they might not want to pay or think they should have to pay,
Right.
and that might be one way of tackling it.
Yeah, once the tree's fallen, it gets a little bit iffy, but if you have any kind of inkling that you've got a dangerous tree that surrounds your property somewhere, start a paper trail at that point in time. Be proactive. Do whatever you can to make sure to let people know that they've been put on notice, and then keep copies of all that stuff. It's not going to necessarily protect you or help you, but at least that's the best way around. We've got less than 2 minutes left here, guys. We've got probably a lot of end of summer cookouts going to be happening between now and maybe Labor Day. If somebody comes to your house and gets injured on your personal property, how liable are you?
Well, it really depends what happens and how it happens. What I always say to people is make sure you have homeowners insurance. Things do happen and accidents do happen, but if it's just like any other case, Dave, you have to, the injured person would have to demonstrate and prove that the person that owned the home was negligent in some way. And if they were able to do that, they may very well have a claim. If not, homeowners insurance, no-fault insurance very well may cover it. So,
Right.
if there's something on your property that poses a danger, you want to fix it before you have anybody else on your property.
Now, if a bar overserves you, then they're responsible. But if your buddy Steve next door gives you an extra beer when he knows that you're sloshed, he's not responsible, or is he?
No, unless you're serving to a minor, you're pretty much going to be safe in South Carolina, although morally you might not be. You still want to do the right thing and get people home safe, but you're not under the same responsibility that a bar would be.
Tell you what, we're going to wrap things up here right now for this week. When we get back together next week, we're going to be talking about workers' compensation. So if you have any questions about workers' comp, you can get it to us in advance if you want to. Our email address is legalaccess@WMBFnews.com, legalaccess@WMBFnews.com. Workers' comp next week. For Ian McGuire and Rick O'Neill, I'm Dave Priest. See you then.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information provided in this program is purposefully broad and does not constitute legal advice. Please